So, have you? No, 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 it's there. No, it's not. Why are you going? It's already there. Participants are there. You remove that in person. Picture. Oh, it's there. That's it. If you off, you other Zoom off. It's not sound.
Volume.
New phones. is her face only. Or ask that Akshata, no?
My lordship, with my lord's permission, 30 lords have moved a matter on Friday, my lords, to be taken up for today. It has not been listed, my lords. My lords had accepted the memo, my lords. The child has been removed.
But it's a father's
To
appeal.
be taken up at 2:30, my lords.
So it's a father's appeal. The only matter pertains to my lord where my weekend visitation has been denied, my lord. Only with regards to weekend visitation, I filed this petition. It may be considered 24, my lord. Tomorrow, my lord. So it's been one.
My lordship, on fresh matter, 125 proceedings, 2:30, my lord.
Respondent will be getting a petition
FLW,
by
because the heart attack has been sustained by the petitioner. Order passed in the November 23, my lord. Please, ma'am, tomorrow. Ma'am.
The petition is filed by wife.
but divorce proceedings are initiated by the husband before trial court. There is a stay of proceedings before this honorable trial. Since the divorce proceedings are stayed, I'm moving the money. We have filed objections.
Your Honor, the matter is for the settlement before the family court. A DD was to be prepared and the matter was supposed to be listed today, Your Honor. But the matter has been deleted from the. Your Honor, the husband has complied duly with the. Your Honor, I apologize. The matter may be posted for tomorrow, Your Honor. I'm grateful, Your Honor.
Appearing for the petitioner, Your Lordship, and the matter is to be taken up tomorrow as the Honorable Trial Court at Chikballapur has passed an impugned order to pay litigation expenses to the respondent of an amount of 10,000 rupees, whereas I'm a farmer and I would like to seek a stay on the proceedings as the matter has been listed to 11th. Your Lordship. MC 96. 2024. 2024. Tomorrow. Your Lordship, kindly, the matter has been listed to 11th for adverse orders, Your Lordship. The trial court is saying. No, Your Lordship, the IA has been applied in 2025, April 2025. Impugned order, apologies, Your Lordship. It was on 3rd of May, 2025. Much obliged.
Serial number 18, a short accommodation may be.
I'm for respond number 1, wife. Honorable Court has reduced the maintenance to 8,000, my lords. So wife and a child is also there, my lords. They're not able to sustain. So I'm requesting for a date tomorrow, my lords.
Which year is that?
4 minutes.
Why all those 24 matters have to be taken up tomorrow itself?
Let's, there's some urgency.
Some other
my
day?
lords. 13th, my lords.
We'll see. Yes.
Obliged.
Serial number 18, my lordship. A short accommodation may be given, my lordship.
That's your writ petition. 24 writ petition.
Yes, my
Coming
lordship.
up for preliminary hearing. Why accommodation?
See, a senior is not available, my lordship. Yes, ma'am.
We'll see. We'll see when the matter comes. Then we'll adjourn.
Serial number 22, madam. Appear for the respondent. I am also filed the counter petition, madam. In RPFC 197 for 24.
Post along with that. So it's after 2 weeks.
24.
Yes. Next.
Lordship, serial number 24. I am for petitioner. Likely to be settled next week, kindly next week.
No, there is a report, KMC report dated 24.
Not settled, my lord.
We
I
are
have moved the
settling.
matter, man.
We are settling it next week.
The
Upon
matter will be
report
called, my lord.
settlement.
I'll hear the terms, please.
Let it be called. Yes. Then we'll, these are all part-heard matters. Where is list number 3?
List number 3 for matters referring to local adalat.
Oh, all these matters are referred to the local adalat. Yes, call the list.
List number 1 for orders matters case number 1.
My lordships, I appear for the petitioner in this matter, my lordships.
Why the memo is moved?
My lordships, the address of the respondent is the same as in the trial court, my lordships. There he received the notice and he is awaiting the notice in this matter before this Honorable High Court, my lordships.
What the postal shara of the where is it? No such person.
He is a government employee, my lordships. He is a BMTC traffic manager.
Working where?
Working in the Bangalore Metropolitan Transport Corporation in the very same address.
Furnish that address.
I have furnished the very same address, my lordship. Page 14 is the petition. Page 15, my lordships. I have taken out notice before the trial court to the very same address of his employer. Here he receives the notice.
No, there won't be any transfers.
No, my lords, because this is within Bangalore itself, and he's a traffic manager. As per my instructions, he's still working in the very same office. And page 7, page 7,
Get the correct address, correct address in the sense, so and so traffic manager and all. With that description, you furnish the address, then go to submit the petition. The respondent is working in Bangalore, and on the very same address, earlier notices were served, and he is awaiting notice. It is submitted that he is working as a traffic controller. The petitioner shall furnish the full description of the respondent within a week.
Hello, President.
Great.
Preparing for petitioner. I am filing a withdrawal memo as the matter is not maintainable for this now.
Officers raised an objection with regard to the maintainability as the petition is filed, questioning an interlocutory order. A memo is filed seeking to withdraw the petition with the liberty to file the appropriate proceedings, questioning the impugned order. Accordingly dismissed as withdrawn with the liberty. And the appropriate application shall be filed within 15 days. Official return all the record.
Much obliged.
Here for respondent in last occasion, you lordship direct them to pay the arrears. Since from 2019, they have not paid.
Petitioner is ready to pay 20%.
What is the intermodal?
Total amount is 26,40,000.
Yes.
No, there is no intermodal in this.
No,
No intermodal.
Oh. From 2021, you are not paying anything.
2020, my lord.
19 December, order was passed.
My lord, the thing is the petitioner
Why
is
did you
not.
not? Why have you not filed the execution
Hello,
proceeding?
we have also filed the writ petition, my lord. Another writ petition connected matter.
No, that's a different aspect.
Well-
Whatever amount that is there granted by the court, it has to be paid. You should file the recovery proceedings.
Yes. If they are
If they're ready to pay.
20%. My lord.
respondent also present, she is unable to maintain
does
the
it matter?
children's also.
Oh, how does it matter if the respondent is present before the court? Where is your writ petition? Let's see, what is the writ petition about?
Impugned order, my lord, page 48.
What is the amount granted?
40 lakhs.
40,000.
20 plus 10, 10 plus 10, for total 40. Since from 90.
20,000 to the wife and 10 each to the children.
Yeah.
What is the occupation?
Business, my lords. The business is in loss. Presently, the petitioner's business is in loss and is not.
How the court can understand that?
uh,
Is there any material before the court?
I'll file the relevant memo to the section. I'll file the memo to the section, my lord.
You have filed.
I'll file it, my lord.
He is earning more than 10 lakhs per.
You file a petition in 2021 and keep quiet till 2025.
My lords, the respondent is earning very well and she is maintaining herself from 2012, my lords. When I filed the petition for in 2018, she has
So
filed
what was the material before the trial court to say so?
Trial court rejected their application. Page.
Let him submit, he is a petitioner. What is the material before the trial court to show that the wife is earning?
My lords, I will take your lordship.
What are the documents you have filed?
I'll take your lordships to page number 70, annexure H, my lords.
This is partition deed.
It's a partition deed which is in the name of the respondent itself, and annexure J.
What is the deed? What is the property?
It's a partition deed, my lords.
Between whom?
Respondent's family, my lord.
So, If you get a property, that is sufficient.
No, my lord.
What is the nature of the property and whether she is deriving any income from that? And what is the evidence in that regard?
No, my lord, the respondent is getting rents from other sources.
Show from the order. You just can't simply say something and the court can't consider all that. There should be some evidence. There is evidence. Please read the order. Come prepared. Tomorrow we'll dispose of.
FF for petitioner, my lord. The application filed by the father, my lord, seeking custody of child.
It's not claimed. Notice to respondent returned as per the procedure as not claimed amounts to deemed service of notice. Yes, print the name of the party. Does this matter tomorrow? Yes.
Petition.
As per the postal
I file a memo
notice to
that matter has been
respondent.
settled between the parties and the same has been disposed of before the trial court. In fractures.
Notice to respondent returned as approved deemed service of notice. A memo is filed by the petitioner stating that the main MC, that is MC number 677 of 2021, itself is the matter is settled and disposed of on 37/2024 before the family court, and the petition has become infructuous. Accordingly, dismissed as infructuous. Memo is taken on record. The 6.
I'm appearing for the respondent.
Notice is served, madam, this today, and we have complied the order, interim order passed by this court.
Complied with?
Please.
Have they complied with the interim order?
No information. No idea, my lords.
Land counsel for the petition submits that they are complying the order passed by this court. Dated
Dated 6/6/2024.
dated 6/6/2024. Land counsel for the respondent to get instruction. This is matter after 2 weeks.
Please.
If the amount, if there is a direction to withdraw also, the order.
We are paying, no, there is no direction. We are paying the.
Directly to them.
Please, that.
The amount that is deposited by the petitioner, the respondent is at liberty to withdraw. Yes.
Please.
My lords, kindly date may be fixed in this matter, my lords. 7,500 awarded
We'll
is
see,
challenged
we'll
in
see,
this
we'll
petition.
see. Yes, next.
For the petitioner, my lords.
Yes.
My lords, the compliance will be done before the next date of hearing.
A week's time is granted.
My lords, there is an urgency in the matter.
Huh?
Maybe there's an urgency in the matter. It may be posted on 19th.
Yes, this is on 19th. By the time within a week, or within 2 days, the office of objection shall be complied with. Yes, if complied with, list on 19th.
Grateful.
There is only one office objection, non-filing of interim application, your lordship, for maintenance. You will be permitted to file that. There is a warrant has been issued against the husband, your lordship, for non-payment of the
When is
estate.
impugned order?
Your lordship, impugned order is directing to pay.
The order is in the month of February 2025.
Please, your lordship.
You don't comply with the office objections.
Your lordship, impugned order, your lordship, ex parte interim matter has been granted, your
When
lordship.
did you come to know?
Please, your lordship.
When did you come to know about this order?
Your lordship, immediately on notice, your lordship, I filed the application, your lordship. It's a ex parte interim order, your lordship. Initially, it has been ordered. Your lordship, I have filed a decree for divorce, your lordship, which has been granted. She filed an application stating that I need a permanent alimony, for which 10 lakh rupees has been granted by the trial court, your lordship. Out of 10 lakh rupees, 2.5 lakh rupees I have filed, your lordship. But the respondent wife, your lordship, what she has done, suppressing the facts, stating that, misleading the court, stating that I have filed an appeal before the High Court, and I have not received any kind of permanent alimony.
When the permanent alimony is ordered, why did you pay only 2.5 lakhs?
No, your lordship, deposited 2.5 lakh rupees, your lordship, out of 10 lakh rupees, I have
When was
deposited.
the decree of divorce?
Decree of November 2024, your lordship.
As per the, when you're supposed to pay the entire amount?
Your lordship, I may be permitted to read the
Yes.
page number 60, your lordship.
Yes.
The petition filed by the petitioner against the respondent under section 13(1)(1)(a) of Hindu Marriage Act, your lordship, second para, your lordship, operative.
Within
I
2
number
months.
60.
Within 2 months.
2 months, your
When
lordship.
is the order? From the date of order.
Your lordship, I
On
have
date
paid
of-
2.5 lakh rupees, your lordship,
That
presently.
is not, that's not the, you don't pay the amount. And when some order is passed by the court, you come to the court.
Your lordship,
How is
what
it right?
award has been granted, your lordship, permanent alimony is 10 lakh rupees. For the bona fide reasons, your lordship, I have paid 2.5 lakh rupees, your lordship. But so far, she is seeking again, your lordship,
Called bona fide reasons.
your lordship,
5th November 2024 is the order.
please.
So you should have paid by January 2024, 2025. You have not paid.
Your lordship, I have deposited 2.5 lakh rupees, not full entire amount,
The
your
court
lordship.
again the same
Because I want to
information.
challenge this amount, your lordship, it is excess amount, your lordship.
Just
it has
no,
been-
that's what you said. That on the pretext that you are going to file an appeal.
Not me, your lordship, she is stating that she has
What
filed.
she
it.
stated before the court, but that is what you are also going to do.
Your lordship, sir, not entire amount, your lordship, I am not challenging for the
What
entire
is that? What is the maintenance? So let it.
Your lordship, 20,000 rupees again, your lordship, payment, your lordship, is,
Continue to pay that.
your lordship, it's a exported or already, let her, your lordship, receive 2.5 lakh rupees.
So already the limitation period is also over. You have not filed any appeal. You have not sought any stay of the.
Your lordship, I have to make arrangements of the money as well as for the, your lordship. I'm not, I do not have a potential source of income, your lordship. I have suffered huge loss, which has been considered by the court also. Your
You would have preferred an appeal by this time.
lordship, I have to file the appeal, your lordship, due to some family reasons, your lordship, I could not make it, your lordship.
Why should the court interfere?
Your lordship, 20,000 rupees is a huge amount, your lordship. Where
What is granted?
20,000 rupees, your lordship. Your lordship, by one side, permanent alimony is also your lordship, and the other side, your lordship. Let her come and say that your lordship, if she is.
You continue to pay. It will be subject to the result of the writ petition.
Your lordship,
And the court will decide.
I may be permitted to deposit in the court at least, your lordship, so that I can adjust the amount for the permanent alimony in the event I have success in the criminal petition, your lordship.
By way of the order impugned, court had granted an amount of rupees 20,000 as maintenance to the wife. Learned counsel appearing to the petition submits that he had filed MC number 612 of 2023 seeking divorce, and the same was granted on 20th November 2024, and the court had granted permanent alimony of 10,000.
10 lakh euros.
10 lakhs has already deposited an amount of rupees 2.5 lakhs. And as he is not in a position to pay the said amount, and in view of his difficulties, he could not even prefer an appeal, and he is taking steps to prefer the appeal. And in the meantime, court had granted an amount of rupees 20,000, which the petitioner is not in a position. It is submitted that the wife cannot have the permanent alimony, and at the same time, she cannot seek for the monthly maintenance, considering the submission of the land council and balancing the interests of both the parties. There shall be stay of all further proceedings on the condition that the petitioner shall deposit an amount of rupees 1 lakh and continue to pay 20,000 by 5th of every month before the trial court, and the wife is at liberty to withdraw the same. Notice.
Your lordship, stay, your lordship. I may be permitted to deposit in the court, your lordship.
Stay on that condition, that 1 lakh and continue to pay 20,000.
Your lordship, I may be permitted so that I can adjust the amount to the.
Court, you paid in the suit account, from that she will withdraw. There will be an account for that.
I may, for your lordship, it will not be adjusted for my permanent alimony, your lordship.
That whether the wife is entitled for the maintenance when she has already granted permanent alimony will also be decided by this court once the notice is served on the respondents and whatever the amount that is deposited and received by the wife is subject to the further orders to be passed by this court. Yes. Office objections shall be complied with within a week.
Please.
Within a week, office objections to be complied with.
Please.
I am for the respondent.
I am filing the office of that I have not filed the return statement in the suit filed by the, I am producing a copy of the. That is the only office objection.
The written statement will be purchased before the court. What is this? What is that submission, ma'am? I didn't understand.
The suit is filed by the respondent against the wife for recovery of a sum of 1,200 because he has spent for the construction of the house property of the wife. In that, I have filed the return statement.
What is that submission? I'm not able to understand.
No, typing return statement will be produced before the court. Return statement.
You produce before the court when you're supposed to do it.
I didn't have the copy at the time when this.
No, you should do it before the registry. Why should before the court? That can't be a submission at all. And on that submission, why should they place it before the court? Everything they'll place it. Take that. Do it. Whatever you have to do it before the registry.
But that is the only objection.
That you do it, not here. Office objection shall be complied with within 2 days. And after the office objections are complied with, list is a matter.
Date may be given.
The moment you do it, it will come. That's what I said.
Please.
I represent the petitioner. But on 25/2025, I was permitted to serve the copy upon the writ petition to the counsel who represents the respondent in the trial court. But I have served and I have also filed the acknowledgement in the office on 4th. I have filed it on 4th.
Is it listed? What is the counsel's name?
They have received acknowledged copy
Please
of
write in this memo. You are supposed to write who is the advocate on whom you have served. Please give it to him. This paper in the memo. You please mention. Call the next case. Why memo is moved in this?
My lords,
Notice is not served.
I have already served, my lords. The respondent is also present. My lords, these two matters, 11 and 12, my lords, arising from the same MC number. I am respondent of this writ petition, madam, and I have received the hand summon, only one page. I have not yet received the writ petition.
No, you have to engage a counsel, is it not?
No, I want to pray to this court.
And then you have to appear before the committee. To appear as a party in person, you have to appear before the committee. Then basing on the committee's this thing, then you can appear.
Today is the first day, madam, so I have come to pray to this court.
That's what it is submitted after receiving the notices. The party, the respondent is present before the court. He submits that he wants to appear as a party in person. Then counsel for the petitioner shall serve the complete set of papers on the party in person.
Already dispatched by court also to his address. I have not.
Give it.
We will give it.
It will be easy for both of you. And the party in person shall appear before the respondent shall appear before the party in person, the committee.
My lords, I request for a stay of the proceedings, my lords, because the stay maintenance or application, my lords, of the wife has been rejected on the ground that, my lords, there is no, she's all capable. Earlier, already in.
What is stay in that?
My lords,
Wife's application is dismissed.
Please.
Why should we stay?
my lords, the proceedings are brought by your husband, my lords, and the matter is posted for evidence now.
No.
And without assets and liabilities, my Madam, submission. I want to submit here.
Please wait,
May.
please wait. You cannot submit.
My lords.
No, please understand.
Please.
Now, if an order is passed by the court in the proceedings initiated by him, if he fails to pay the maintenance, then it's a separate, altogether a different case. Here is a case the court had dismissed your application. Now, whether it is right or not, court will adjudicate. Why should we
Please.
stay the proceedings?
My lords, not, that is in serial number 12 and serial number 11, my lords, an application for directions to the respondent father to come and see the child in compliance to his visitation application that was allowed. And now, my lords, in 2019, it was allowed.
Is it a GNWC or MC?
MC, my lords, but the child is undergoing a therapeutic treatment before the doctor. All records were produced. Trial court rejects my prayer only on the ground that, my lords, unless he is interested, we cannot direct. Now, my lords, that is not in the welfare and the interest of the child. That is against to the laws laid down by Honorable Apex Court in Rosie Jacob's case and as well as other cases, my lords, where the welfare of the child has to be looked into. And
This is not a GNWC petition.
my lords,
This is not a GNWC petition.
no, my lords, it's a
MC.
It's a MC matters, and in section 26 of it, Hindu marriage, we have filed an application, interim application, seeking directions for the upbringing and better welfare of the child to go to the psychiatrist where he is taking treatment along with the child. We sought for a direction to them.
In that case also, we don't have to stay the proceedings.
My lords, my only submission is this, my lords. Now the matter is posted for evidence. Now the cross-examination of petitioner has to go on. And in diverse proceedings brought by him, and I have to demonstrate what is the financial capabilities also. In this maintenance case, my lords, Neha's case, Neha's judgment, affidavits and liabilities, they were not at all directed to be filed. No, the husband, nor...
For that, there should have been a separate application.
My lords,
So just like that, this saying of.
my lords, let there be a direction at least to file assets and liabilities. Because, my lords, the mandate of...
Did you ask the court about this?
Please, my lords, we have asked in the application. My lords, I have produced even the Neha's judgment.
Not about this.
Two.
There are two
Two
petitions. One is with regard to, as you're saying, that the father has to see the child.
See the child.
Number two is her maintenance.
Maintenance.
And then in both these things, where is this prayer with that prayer with regard to assets and liabilities should have been much before.
My lords, it was application for maintenance was filed in 2022.
But then that time, when he is not filing, you should have raised an objection before the
My
court.
lords, that application was decided only in 2025, my lords, February. Until then, it was kept pending. And when
But you know,
we
by
pressed,
the time, by the time all the material is before the court, you have filed an application, they would file objections to
objections were also filed in 2025 minutes. Until then, rejoinder applications and records were being brought. Now, my lords, at the time of hearing, we pressed the court to insist for assets and liabilities. And assets and liabilities in compliance to Neha Sharma's, Rajesh Sharma's case. And without even taking the assets and liabilities, now, my lords, that application is rejected outrightly.
on the ground.
On the ground that, my lords, in 2018, already IS-4 was decided. My lords, this Rajneesh Sharma's directions have come in 2020. In all pending matters, it is the duty of the family
All
court.
pending matters where the application is not decided.
My lords,
Not that after
that-
once an application is decided,
My-
again, as per Rajneesh versus Neha, court will again.
My humble submission is this, my lords, respectful submission. Those assets and liabilities will have to be essential for securing all the records to ascertain even the permanent alimony or even the interim maintenance that is going to be decided in the end. My lords, for that also, they
Come up with these objections, we will decide.
My lords, until then, 12th of March. Now, there is one more difficulty what this council is facing. My lords, there is a directions got by the respondent from this honorable court without even I was not served a notice. And there, my lords, there is a direction of this honorable court to decide the matter expeditiously as possible without delaying the dates. Now, my lords, in view of that direction, the court is hurriedly proceeding ahead. It results in multiplicity and it results in unfair procedure, my lords, because without records being obtained by the directions being issued in compliance to Rajneesh Sharma's case, the affidavits and assets and liabilities, we cannot conclusively decide about the permanent alimony nor even the interim maintenance. That's the council submission. Now, my lords, in view of these things, until next date, my lords, whatever date he comes, tomorrow also I'm okay, day after tomorrow also I'm okay. to decide only on these grounds. Now, my lords, the mandate of Supreme Court is to secure assets and liabilities and then decide the MC case with respect to dissolution as well as permanent alimony or interim maintenance, my lords. Without following that procedure with the dictum of Honorable Apex Court, this application is rejected. Now, matter is hurriedly proceeded further.
One way this court has granted, or coordinate bench of this court has granted that order.
Coordinate bench.
So a coordinate bench of this court will pass an order to expeditiously decide, and this court will stay, don't decide it.
No, my lords.
For no reason.
My lords, tomorrow only I am okay to proceed, my lords, without.
For the court, that anyway he has to appear.
My lords, assets and liabilities, without my counsel's endeavor is to pursue this honorable court only on point that, my lords.
Court is not interested to grant.
My lords,
Yes, like,
page.
that's not the way the cases are dealt.
My lords, page 1, my lords.
Impugned order passed.
February 20.
Where are we now?
My lords, we filed it in April itself, my lords.
And then what
Vacation was there, my lords. During vacation, notice was ordered, my lords. We sought for immediately before vacation.
I'll not, you can ask for anything, but not the stay.
My lords, it results in hurried disposal of the matter, my lords.
If I can speak
Page
one sentence,
128 may kindly be
Is
taken.
this matter on Thursday?
My lords,
Will not.
tomorrow, my lords, if he is ready, my lords, I am ready
Has
to.
to go
On
and
only
appear.
one point, my lords.
Please understand,
Please.
he has to go and appear before the committee.
No, my lords, he's going to come in person is what he says.
For that, he has to go before the committee. Just
My lords,
like that, he can't come to the
my lords,
court.
my
and-
case is posted on 12th, my lords, day of tomorrow. The court is going to go hurriedly, my lords, until next date. Otherwise, my lords, it results in procedural hazard too.
Next.
My lords,
This is matter day after tomorrow.
my lords, day of tomorrow, 12th is again, there is a
Then
family court matter.
on
my lords.
13th,
13th is the
Tomorrow,
family
my
court
lords,
matter.
day of tomorrow.
day after tomorrow.
No, day after tomorrow is family court matter, madam. 12th is family court matter. 13th is also DV case matter. So I pray for the Monday.
These are the difficulties, my lords. The litigation expenditures.
On this matter on Monday. Yes, next.
Stay may kindly be.
Yes.
It's a maintenance issue, my lords. 12 is I'm only,
Both
same
the matters.
parties.
Yes,
My lords, at least direction to us, secure assets and liabilities, my lords would.
that we will do it comprehensively, looking at both
My
your.
lords, meanwhile, the matter will be closed, my lords, there. Again, it results in multiplicity. That is the only effort, my lords. Until next date, my lords, within a week, nothing
Yes.
much.
No
Query
representation.
for Petitioner, my lords. My lords, kindly reissue the notice, my lord.
What happened to the earlier one?
And it has not been served, my lord. It is in
What was the
await.
direction earlier? Will and counsel for the petition is permitted to take out hand summons and serve a memo to that effect. If the memo is served, list the matter. The memo is filed, list the matter immediately. Yes, next.
Much obliged, ma'am.
For the petitioner, my lords, 1 week time may be given for compliance of officer objection.
Yes, a week's time. Next.
I have mentioned the name of the counsel, my lord, to whom I have served the copy.
As for the order passed to this court, notice is served and the counsel accompanies the respondent and a memo is filed to that effect. It is stated that notice is served on the advocate, Srimati
Seema Parveen, my lord.
Parveen. This is directed to list print the name of so and so. This is matter day after tomorrow.
Please. But I'll furnish the translated copies, my lord. I'll furnish it.
Yes.
I'll furnish it.
Translated copy shall be furnished.
Please.
I appear for petitioner in this case, my lordship. Lords, the parties have arrived at a settlement, my lords. There is another, my lords, an appeal, my lords, which is listed for today. Lords, we are filing a detailed compromise petition in that.
Shall I list this also along with that?
No, my lord, conversation of delay, my lord, they have not paid the maintenance for the child. For 15,000 per month. We have to file our objections. The other case is MC case, my lord, there we are settled, not in this case.
it is submitted that the MFA,
Yes, my lord.
MFA, the parties have varied a settlement. The registry is directed to
4732.
post this matter along with MFA number so and so.
Appearing for petitioner, my lordship. There is a delay of 63 days. It may be concurred, my lordship.
In 16.1, I am for the petitioner, my lord.
So you take notice.
I will
in
take
16
notice and I will undertake the
Mr.
file.
Srinivasa GA takes notice in 16 on behalf of the respondents. Will condone the delay.
Please.
I number 1 of 25 is filed to condone the delay of 63 days. Same for the reasons stated. The delay is condoned. Yes. What is the matter about?
Like enhancement of the maintenance, my lordship.
This is matter next week. Yes, next.
Stay may be.
Date may be given, my lordship.
Stay may be extended till.
Much obliged.
Yes.
Interim order may be.
Interim order, look at it in which matter granted is extended till the next date of hearing.
Please. Great.
Petitioner filed an application to recall the order. There was a typographical error. The office registry had raised 3 office objections. I have specified in my interrogatory
Which
application.
order to be recalled? 24
Order to be recalled.
1 week time is granted to comply with the office objections.
Yes, my lords.
For this
There are-
matter on, and by the time the office objection is not complied with the writ petition shall
Yes,
stand.
it was complied because we made written submissions.
No, if it is complied,
Yes.
then where
No,
is the?
it was, my lords, I'm pleased to say that, my lords, it was not posted before the honorable court. We had made written submissions. If your lordships can kindly see that, my lords, there is a typographical error in the impugned order itself. Order is passed on IA number 5, whereas while concluding the
1 minute, 1 minute. The counsel for the petitioner partly complied the office objections.
Yes, ma'am.
The following objections had to be clarified.
Yes, ma'am.
Clarified.
Yes,
As per the prayer copy of IA number so and so, objection and IA to be filed.
yes,
That's the objection.
3 office objections, para numbers to be
I'm
stated.
looking at one. Only one objection.
Thereafter, they have raised,
Then you said counsel submission.
yes, my lords. Counsel
Post this
counsel-
writ petition before the court for orders. That's how it has come up.
Yes,
Then the court said you comply with the office objection.
yes, my lords. Prior to that itself.
So
on-
prior to that, we are not concerned.
Yes.
When this matter is listed before the court,
Yes,
this was the objection.
That's right.
I asked you to comply.
Yes, my lords.
So why should this
We-
order be recalled?
My respectful submission is, if your lordships can kindly see the written objections, written submissions, for the sake, my lords, 3 office objections were raised. It was already,
Please come to, don't go back to that.
yes,
This note, this is dated 19/9/2024. You want to look at what is there in the objections?
my lords, 24th of September 2024, your lordships have passed this order.
Correct. Please look at, we'll call the other case, we'll look at it in the meantime. Next one. When did it live? When was it listed earlier?
It's listed on 8/8/20. Interim order granted earlier extended till next day. Previously, it is listed on.
It's a request of land counsel to petitioner. This is matter after 4 weeks. Don't extend interim order.
Counsel for the petitioner, Lordship. Your Lordship, we have filed this petition seeking expeditious disposal of the matrimonial case.
Here is MC.
MC is pending before the 3rd Additional Family Court of Bengaluru, Your Lordship. It's the matter filed in the year 2020.
MC of which year you said?
2020, Your Lordship.
20?
2020.
2020?
Yes, Your Lordship.
Where is that report? There are 60 matters pending of the year 2020. Why should we grant direct the court to dispose of your case?
Your Lordship, over the past 5 years, there has been no substantial progress in the matter, Your Lordship. The cross-examination stage, it's been reopened for the third time, Your Lordship.
But on what date?
In the year 2024, Your Lordship. First, it was posted in the year 2022.
So
After
what has happened from 2024?
no stage
Have
has
you filed the proceeding sheet?
Yes, Your Lordship.
Where is it? You are the petitioner before the court?
Yes, Your Lordship. Annexure B call, Your Lordship. 31 to 72. An IA for maintenance was filed in the year 2022, Your Lordship. Till now, the matter has not been heard, nor has the respondent filed their assets and liabilities, Your Lordship. We have made multiple representation pressing on the IA, but till now it has not been heard, Your Lordship.
No, you yourself are absent on so many occasions.
No, Your Lordship.
You are counsel for the petitioner.
Yes, Your Lordship.
Come to page number 57.
Yes, Your Lordship.
No representation on 18/4. 19/4, no representation. Then again 24, no representation. 28/5, no representation. 12/6, no representation.
Your Lordship,
Again 16/7, no representation.
We filed the wakalat in the year 2020-24 year, NOC wakalat.
That's not, court is not concerned about you.
Yes,
Court is concerned about your client.
Yes,
You
Your
yourself are absent so many times before the court. And now you say that something is not right with how the case is dealt with by the court. You were present only from the last 2 occasions.
No, Your Lordship.
The petition is filed.
Your Lordship, the respondent has been willfully absent on several occasions, Your Lordship.
You were also. Who will answer to that?
And regards to the IA number 2 for the maintenance, Your Lordship.
The petition is filed.
The petitioner, Your Lordship, one submission, Your Lordship.
And counsel for the petitioner that the respondent, the court, the matter is pending from a long time. The respondent is taking unnecessary adjournments. As such, there shall be a direction to the court to expeditiously dispose of the matter.
Your Lordship, one submission, Your Lordship.
Yes.
The petitioner's minor son has graduated his 12th standard. Now he has to get admission in the college, Your Lordship. She has no sufficient funds to get the admission, Your Lordship. And IA for maintenance not. Your Lordship.
When is the IA filed?
2022, Your Lordship.
It is not decided till now.
No, Your Lordship. Nor have the respondent filed their assets and liabilities.
This case, write it on a paper, explain about the which court and all. Bring it to the registrar R&S. Today there is something. This case is pending before the 3rd additional principal judge, Family Court, Bangalore. It is the contention of the counsel that an IA that is filed in the year 2022 is still not disposed of, and the child has completed his 12th standard, and she is not having the financial capacity to join him in a college. It is submitted that hence there shall be a direction to the court. The MC is of the year 2020, and as per the statistics, there are about 60 MCs that are pending before the 3rd additional principal judge, Family Court, Bangalore, and there cannot be a direction to the family court to expeditiously dispose of this matter.
Your Lordship, at least on the IA time-bound disposal may be.
Wait, listen to the order. There cannot be any direction to the court to dispose of this matter out of the way, whereas the other cases of 2020 are pending. Considering the submission of the learned counsel for the petitioner, when an IA is filed in the year 2022, this court is not able to understand why the IA is kept pending. till now. Even if the respondent is not cooperating and not filing a statement of assets and liabilities, the court has to proceed as per the law laid down by the Honorable Apex Court in Rajneesh versus Neha. And eternally, the IAS cannot be kept pending. In that view of the matter, the writ petition is disposed of, directing the court to expeditiously dispose of the IA pending for interim maintenance. The court shall not grant unnecessary adjournments to either of the parties and shall dispose of the case in accordance with law. No notice is issued to the respondents as disposal of the case is in the interest of both the parties.
Much obliged, Your Lordship.
Yes.
Drawing this.
You want to withdraw?
Yes, ma'am. It's a matter of.
Morning, you were opposing for this. Is it
In
not
the other matter, ma'am.
Oh, it's other matter.
Yes, ma'am. Undertake to file wakalat for the respondent.
So and so submits that as instructions to file wakalat. Learned counsel, but the petitioner has filed a memo seeking to withdraw the petition. Accordingly dismissed as withdrawn.
Achha.
Till number 21.
My lords, I'm the petitioner in this writ petition that I filed.
Yes.
I've got C form issued by the party in person committee, so I may be permitted to
Where is the
argue
impugned
the
order?
case. The impugned order is Annexure A, page number 15 to 47.
Come to the operative.
If I may please read the operative portion, please.
Yes.
Page number 45, last two lines.
2 months on third Saturday between so and so in the respondent's house or at any neutral place preferred at the choice of the minor child and the respondent with prior intimation commencing from
April 2025
What is your
till the
opinion
final
on this order?
disposal. Further, it says that petitioner shall pay maintenance amount already granted in criminal miscellaneous 245 of 2018 to the minor child in the better interest of the child. I may be brought to the notice of this honorable court that this petition that I filed a writ has enumerated from a GWC case from the family court, third additional family court. This criminal miscellaneous which is referred here is in the MMT, Metropolitan Magistrate Traffic Court 1, which has no cognizance with this particular case whatsoever. Let me please bring some factual metrics of.
Which portion of the order you are agreed with and what is the interim order that you are seeking?
I'm agreed with both of these orders. There are two.
As far as miscellaneous petition, you have a right, you have a duty to take care of the child.
Correct.
You cannot say that I'll have visitation, but I'll not pay. And all these technicalities court will never consider in this GNWC matters. When there is an order, there is an order by the court and you don't comply with it by one of the court,
Yes,
and in the other court you want an order.
No, my lords. So, if I may also bring your notice to Annexure E, which is on 70 to 73. In this criminal miscellaneous petition, I have filed for change of circumstances, and the order that has been referred to here in criminal miscellaneous is an ex parte order that is also annexed in page number 68 to 69, where it says.
How much was granted in the criminal miscellaneous?
It is on page number 68, and it is granted 8,000 rupees for both the mother and the daughter, wherein the mother is earning as on date 2,10,000 rupees on an approximate amount per month. That is her salary. Wherein when this ex parte order was passed by criminal miscellaneous, she had hidden the fact that she was working. No assets and liabilities.
What about the child?
The child back then, when the separation happened, the child was 1 year, 4 months old. Now currently the child is 8 years old, my lord. What subsequently happened was the court, the Metropolitan Magistrate Court gave her 12 opportunities to file her assets and liabilities after I filed this change of circumstances, which were never adhered
to. Issue notice to her, let her appear.
Yes,
now,
please,
as far as 4,000 is concerned, which has to be paid to the daughter,
correct,
you
my
have to
lord.
have some responsibility.
My lord, I am jobless. I'll finish in 10 seconds. when she left the house, she sent a message on WhatsApp. This is on trial in MMTC court, and this DWC case is in family court where the court is not aware of these factual matrix. She had sent a message to me stating that all of your educational documents are with me and I will return it back to you. Subsequently, she files affidavits in different courts, both of these courts, saying that she only has scrap papers, and I have no documents related to him. Finally, she submits portion of these papers, my educational documents, to the family court, wherein I get a part of these documents, where she claims she had nothing. I lost my job during Corona, post which I'm jobless and I'm struggling to have a meal for myself. When this is the case, this particular honorable court has no factual metrics on hands.
What is your qualification?
I've done my diploma in electronics and communication. I worked for 10 years in HP as a communication manager. I've requested, there are 4 mediations that were done, my lord. I've requested her, my parents have gone to her house and requested, just give us the documents that you have taken. We don't need anything. On an affidavit, she says she has only scrap papers. On the basis of this, plus irregularities in assets and liabilities, there are 2 contempt cases that are filed before this honorable court, and there is a pending perjury application which is against the petitioner. Now, on this order, only for the maintenance that I have not paid, I'm not deliberately disobeying the court's order. It's just that I am inconvenient at this point in time to make payments. When such order is passed, it will be detrimental for me. I'm not allowed to see the child from the age 1 year.
What about the first point?
First point is also, I have an order from the same MMTC court where it says 2nd Saturday and 4th Saturday for visitation, which was recently modified. That order is a better order than this one. But what happened is, as soon as this order was passed, that order was still pending. The learned counsel who would probably appear if the notice is served, he submits in the judicial magistrate court saying that this order is already passed, you uphold this order. So that order was subsequently passed on these merits. Let me also bring it to the notice. The main contention that the opposite counsel had taken is that they relied on 2 documents. One is a school letter which says stop visitation. Second one is an Aster hospital psychiatrist letter saying that you have to stop the visitation because it is affecting the child. I have filed a contempt as well as a 340 application, which clearly is on an affidavit where the school says we have not given any documentation. All of these are recorded and it is still on the YouTube, where it was before the Chief Justice's court. She submits that she holds a paper and she says we have a letter from the school. So finally, CRPC 91 was filed in the MMTC court, where the court summoned the school for document. That is all subsequently taken care of, and the orders will be passed in MMTC court. Now, with this order, when the court has no factual metrics on hands, this order will be detrimental to me, my lords.
Agreed with orders passed in I number 6 in JNWC number 256 of 2022 dated 11th March 2025. The petitioner party in person is before this court. By order impugned, the court had granted visitation to the father once in 2 months, that's on third Saturday between 11 a.m. to 1 p.m. in the respondent's house or at any neutral place preferred at the choice of the minor child and the respondent with prior intimation, commencing from April 2025 till final disposal of the case. Further, the court has also ordered that the petitioner shall pay the maintenance amount already granted in criminal miscellaneous number 245 of 2018 to the minor child in the better interest and welfare of the child. The party in person submits that while the mother left the father along with the child was 1.5 years old. 1.5 years old, but for 10 years he worked as a manager. And during that time, she takes his entire educational the certificates or with the mother, and she is not able to hand over them. He could not secure employment. It is submitted that the order that's passed in criminal miscellaneous number 245 of 2018 is an ex parte order, and he has filed his application before the court, stating that he is not in a position to pay the pay the maintenance as he is jobless. It is submitted that when the GNWC, when the court which has passed criminal miscellaneous orders in 245 of 2018 is the which court?
One is MMTC, Metropolitan Magistrate Traffic Court
125,
1. The other one is Family Court, fourth additional.
Metropolitan Magistrates Court. And the court, without even knowing what is pending before the court cannot direct the petitioner to pay the amounts considering the submission of the party in person. And the fact that he has already filed an IA explaining the circumstances in which he is not in a position to pay the maintenance, the order dated so and so, as far as payment of maintenance in criminal miscellaneous number 245 of 2008 is date until the next date of hearing. The registry is directed to issue notice to the respondent. Yes.
Much obliged.
Asked our matter 17.
Because, my lords, when the matter was listed on 24 September 24, we did not represent the petitioner on that day. Therefore, your lordships have passed the order.
Because it's coming up for orders, we have passed.
That's right. That's right, my lords. We did not represent and make the submission on that day. What we are doing today, simply because the office objections are so that your lordships order is required on the written submissions that are made. The office objections are that, my lords, complete proceedings copy to be furnished. If your lordships can kindly see the written submission, we have applied to the entire order sheet itself. And in the order sheet, the operative portion of the order passed is also evident. Written submissions were made on 9th September 24.
So,
Yes, please.
as per the prayer of IA number 4, where is that IA number 4?
Yes, please. IA number 4 is at annexure page 68, annexure C. And subsequently, objections are also placed at annexure C1.
Grant an amount of 15,000 for interim maintenance.
That's right. That is
Then
the
what this is, as per prayer, a copy of IA number 4.
Yes.
And objection?
objections is at page number 70, annexure C1.
Page number 70.
Yes, please. This is the objection. It is on record.
Then what is to be clarified in
That,
this?
my lords, I'll come to that, my lords. Kindly see the order at page number 40. Internal page number 19, page number 40. This is the impugned order. Your lordships can kindly see that column 4, number of the application, IA number 5. Order on application under section 195 of IPC 1860 filed by the petitioner, IA number 5. At last, page number 48 may kindly be looked into.
Page number?
48. While disposing of the application, the Honorable Trial Court says IA number 4, which is in fact a typographical error.
What is this 195 IPC?
Well, as we filed this application to take action as against the respondent for filing a false affidavit.
Correct. No, if you
That is
come
the-
to,
yes.
come to the application,
Yes.
where is that prayer that you sought? The application is for seeking interim maintenance of 15,000.
Yes, my lords. On that,
Then please come to the objections. Let's see. This is also pertaining to that.
yes,
Where is your application under 195?
I'll annexure A, page 32. And objections to that application is at annexure A1, page 35.
Something was written with the pen IA number 5, pencil.
We have not written it. We have obtained it as it is.
Then now the court has decided which application, IA number 5
This present
or IA
application.
number 4.
IA number 5. It is a typographical error while disposing of
Where are the objections to IA number 5?
IA number 5. At serial number 3 is the office objections. Please, my lords. Objections.
Objections to
At
IA number
annex,
5.
I'm sorry. Annexure A1, page 35.
30?
35.
Now please come to the impugned order.
Please. Impugned order at page 40. Reasons from 43.
Had you been there before the court, unnecessarily all this exercise, court need not do.
Yes, yes.
Waste of court's time, nothing else.
Indeed, my lord.
An order was passed on 24/9/2024, granting a week's time to comply with the office objections and directed the matter to be listed on 23/10/2024. By the time if the office objection is not complied with, the writ petition shall stand dismissed without further reference to the court. Now the IA is filed, I number
5.
5 is filed, seeking to, for recall of the order dated so and so. It is submitted that on the day, the court, the office has raised an objection as per prior copy of IA number 4 and objection on IA to be filed. Then the council has made the submission. As there was no representation on their behalf, the IA, the court had passed this order. It is submitted that, in fact, the IA that is filed is under section, IA number 5 is filed under section 195 of the IPC to punish the respondent for giving fabricated false evidence with an intention to procure conviction of evidence in interest of justice and equity. The order impugned refers to IA number 5 in the first page of the order. When it comes to the operative portion of the order, the application IA number 4 under section 195 IPC is dismissed. Then council submits that it is a typographical error, and in fact the court had decided IA number 5. Next para, this court has perused the order, the application, that's IA number 4, objections to IA number 4, as well IA number 5, and objections to that IA number 5. The order clearly says that the application under section 195 of IPC filed by the petitioner is dismissed, and that is IA number 5, but not IA number 4. As it appears to be a typographical error, the office objections is overruled, and the claims, the council's submission is taken note of. And yes.
May I request any date in this matter? I regret the
This
inconvenience.
is matter after. Yes.
Regret.
Serial number 22, in serial number 22, the negotiation is going on. Kindly give the date 17th.
Morning, there was a submission made.
Counterclaim also filed along with this.
Yes, next.
17th may be, date may be given. my
Yes,
lord.
date is already given. Yes, next. 23. 17th is asked.
And another case is 197 of.
That's already, he has made a mention
Much
in the
obvious.
morning.
The matter may be listed after 2 weeks. ma'am.
Right?
Still some 60,000 is pending, my lord, arrears. They have not complied fully order of this honorable court.
At the request of non-counsel, the petitioner posed this matter on 9/6/2025. No further adjournments will be granted. Interim order granted earlier is extended till the next date of hearing. We will vacate the interim order and post the matter after 2 weeks.
No.
Conveniently, you can argue.
The pass or minutes.
When there is an order, use it as if no order is passed. You just like that come and seek adjournment.
No, actually, we had a word before coming in this court.
What is the word?
We'll adjourn the matter for 3 weeks.
No. I told you that I will pray this honorable to post the matter for final hearing. Till he is owing 60,000, he has to pay, my lord.
This court has specifically on the last occasion an order was passed granting adjournment, and it is observed that no further adjournments will be granted. Again, the petitioner had sought for adjournment today. This is matter tomorrow. No further adjournments.
The passer, my lord, we'll argue the
Passer
matter.
not possible tomorrow.
Interim order may be extended.
Interim order earlier granted is extended till tomorrow.
Please, ma'am.
Yes.
Lordship, in this case, I appear for petitioner.
Yes.
Petitioner challenged the order of annexure A, my lordship, page 14. Passed by the Principal Judge, Family Court, Tumkur. And IA2, the order on IA2 filed under section 125(3) of CRPC, but the petitioner is allowed. And the petitioner is to pay 15,000 per month. Lordship may kindly see this after hearing my case, this honorable court has granted interim order. Kindly
Out of
see.
the pension amount of rupees 72,000, he is paying 50,000 monthly towards the loan.
Yes.
The trial court, without considering all these aspects, had granted the interim maintenance of an amount of rupees 15,000, which the petitioner is not in a position to pay.
Petitioner is a 70 years old. They lived happily for 40 years. Under the instigation of the daughter, she has filed criminal misdemeanor petition against the petitioner.
When they were separated?
Petitioner is a retired principal. He is present.
Not necessary. Why the party is required here?
He's 70 years old, my lordship, because he is even unable to work. Kindly see, for construction of house, he has taken 35 lakhs.
I asked you when they separated, both of them.
When?
When they are separated, wife and husband.
1985.
They separated in 1985.
Yes, last year only. There he lived happily 40 years.
6 months prior to filing.
He lived 40 years. And she went to daughter's, that son has been barren. For the daughter's welfare, she went to daughter's house. Afterwards, under the instigation of daughter, she has filed the criminal misdemeanor petition. She lived 40 years happily. Next, she doesn't want to come to residence of the husband now. And he has constructed the house which was in the name of wife. He has really spent 45 lakhs. His son also spent 15 lakhs. I produced every document before the trial court also, as well as before this honorable court. Lords may kindly see, he is paying nearly 40,000 loan.
Understood. Yes.
My lords, admittedly, my lords.
They have not made
both
any
got-
counter objection.
Both got separated 6 months prior to filing of maintenance petition, my lords.
How they are separated?
Because there was a pressure on the wife, I mean, the respondent, to transfer the property which was standing in her name. That is the main cause of action which led.
Deny the fact that he has taken loan and out of the pension amount of 70,000, he is paying 50,000 towards the loan and the property stands in your name.
No, property which was standing in my name was gifted by my father, my lords. That was developed, my lords. That was developed when they were in cordial relationship.
Correct.
True, my
For
lords.
that he has, so he is
True, my
paying,
lords.
so you do not deny
I do
the
not
fact,
dispute, my lords.
that 50,000 is paid towards the loan installment.
No, that, please,
So what is left is 20,000 with him.
please.
In that 20,000, he'll give her 15,000. Then what he'll do?
No, my respectful submission, my lords, the property which was standing in my name, in which some developments have been taken place, they are getting the rental income. That is what their allegation is all about, my lords. Because since the property is generating the rental income and all, they want that property to be transferred in their name. For that reason, they drove me out of the house because I was repeatedly telling them till my last breath, I will not transfer the property which was standing in my name because it was gifted by my father, my lords.
No, you say you have
Please.
been driven out of the house.
Yes.
They say you left the house and they're ready to take you back.
No, that is what they are contending, my lords. Even I don't.
Says that he's ready.
Yes,
to
I
That
take
is what they are contending, my lords.
So the petition is also before the court.
True, my lords.
No, if
So does
the
respondent
intention-
also, my lords.
If the
True.
intentions of the respondent.
Yes, my lords.
and as you say it is correct, then let her
The
go.
fact remains, my lords.
At the age of 70.
I do-
and
I-
at the behest of the children, what is this maintenance?
No, I do understand, my lords, because both are senior citizens. That is why the court made an effort to send the parties to mediation, my lords. In the mediation also did not materialize.
BSNL,
because
she has not entered the BSNL also.
Wait, let him submit.
In the mediation also, my lords, matter did not materialize in a fruitful way.
What was
Because,
what
Please.
was your requirement?
well, my requirement, my lords, I concede, my lords, the property which was standing in my name was developed, my lords. The property is yielding rental income, my lords. All the rental incomes are enjoyed by my husband and my son, my lords.
You wanted to give it to the daughter.
No, I have no intention to transfer it to anybody else because it is gifted to my father.
Daughter is not, son is not
No,
your
I'm
son.
not residing in my daughter's home at all.
Your son is not your son. For whom you will
Lords,
spend?
we have 3 children, my lords. One son, 2 daughters. One daughter is residing in abroad, my lords. Another daughter is residing in Bangalore, and son is residing along with my husband, my lords. I was thrown out. I am taking shelter in my friend's house. Kindly see the cause title, my lords. I have stated that I have taken shelter in my friend's house at Tumkur, and now they deliberately mention the address of my daughter's occupation address in the writ petition.
You are saying that it didn't work. It didn't materialize before the mediation.
Mediation, my lords.
What was the proposal?
There was
Why-
no proposal at all, my lords. All that they said, they want me to transfer the property which is standing in my name into their name. That's all. There was no
Absolutely false,
proposal
my
at all,
lordship.
lord. In fact, my learned
Last
friend
week,
submitted
both daughter and
That
his
he is
wife
trying
went to
for
the
mediation.
and paid 18,000 tax. Last week only they went to the
Core benefit
premises.
is
They have paid
paying, my lord.
tax.
In fact, if you
Nearly
lordship see
18,000
the
they have paid.
document what they have submitted.
This land council appearing for the husband submits that he's aged 70 years and he's spending 50,000 rupees towards towards the loan prepayment of loan, and he's left with 20,000.
15,000 he is paying, my lord, not 50. That is what the loan document speaks about. That is what they have produced.
The trial court, before leading evidence, has passed an order.
15 or 1
15, my lord.
15,000. Now I am paying 45,000 loan every month out of 72,000.
No materials are placed.
I have produced statement of account before the trial court also. Trial court does not consider and not led evidence. The honorable court, there is a decision without.
Forget about the decision. First, the facts
Yes,
have to
madam.
be clear.
In the mediation, I asked, she never entered the mediation room also.
Paying 15,000 or 45,000
15,000, court has passed an order.
loan amount.
Loan amount is 48,000. I produced the statement of account.
Pay from, you say that it is paying.
But they have
15,000.
placed 2 documents, my lords, at page 60,
Then what did you write?
page 58 and 60, my lords.
He is paying an amount of rupees 48,000 towards the loan and he's left with 22,000. In that court had granted 15,000.
Lordship, one more submission. After retirement, husband has deposited 20 lakhs in the account of, I have produced annexure M, my lordship.
15,000. He's left with 22,000. It is submitted that
All retirement benefit was deposited.
so he's left with 22,000. It is submitted that the property stands in the name of the wife. And in fact, immediately after the retirement, he has transferred an amount of rupees 20 lakhs to the account of the wife at the behest of the daughter. The wife is fighting this litigation. He also submits that he is ready to take back the wife. And according to the counsel for the respondent, she has been thrown out of the house. Concerning these facts, the parties are directed to appear before the Bangalore Mediation Center on 18th of June without fail.
Previously, it was referred to BDMC only, my lords.
Interim order may be kindly extended, madam.
Didn't appear.
No, we have appeared, my lord. 3 occasions we have appeared. That is what
He
report
didn't
says.
appear.
No, they also appeared. Matter
He
did
have
not
appeared, but she doesn't
appeared
want to
twice,
enter.
my lords.
And in these lines,
They appeared twice, we appeared
a
thrice, my
mediation
lord.
shall be conducted. And
We appeared thrice. First time also they are absent.
this matter after the report is placed before the court.
They are enjoying the benefit of
Interim order may
interim
be
order, my
extended, my
lord.
lordship.
I'm penniless.
ಸ್ವಾಮಿ ಅಲ್ಲಿ ಪ್ರಾಪರ್ಟಿ ಹತ್ರ ಹೋಗಕ್ಕೆ ಬಿಡೋದಿಲ್ಲ ಅವರು.
I'm also
ಗಲಾಟೆ
not getting
ಮಾಡ್ತಾರೆ
the rent
ಇವ್ರನ್ನ, ಅಲ್ಲಿ
also, my
ಹೋಗಕ್ಕೆ
lords.
ಬಿಡೋದಿಲ್ಲ.
I'm also not getting the rent because they are enjoying the
ಬೇಕಾದ್ರೆ
rental income.
ಕಮಿಷನ್ ಅಪಾಯಿಂಟ್ ಮಾಡಿ ಗೊತ್ತಾಗುತ್ತೆ ಏನ್ ನಿಜ ಅಂತ.
I'm okay with that, my lords. If a commissioner,
Court is not okay with any of
true, my lords,
your
but the
submissions.
fact remains, my
This
lords.
matter. Yes, next.
Date be fixed, my lords.
Lordship, interim matter may be kindly
Court is
extended, my
carried.
lord.
Date be fixed, my lords.
The order earlier granted is extended till then.
President, the respondent. The petitioners in this matter, common orders dated 8th of April, on IA 11, 6, 15 and 16. And for the mother in this case, respondent in the court below, petitioner over here. IA number 11, unfettered rights given to the father that all decisions.
Come to the operative portion of the order.
Referring to writ petition 11643, my lord. 4 writ petitions are.
Page number?
I know which writ petition you're referring to, 11643?
Petition 11643.
That's page number 57.
Yes.
IA number 11 filed under 151 of CPC and IA number 15 under section 12 of Guardians and Wards Act and IA number 16 under order 6 rule 17.
Where are you reading? Page 57.
57.
It speaks about IA number 11. That's a under section and
These
IA
are
number 15 also.
common orders that have been passed on
Your question
IA.
which IA is IA number?
I've challenged IA number 11, IA number 6, IA number 15 and 16. The orders passed on IA number 11, 14, 15, 16 and 18.
Who is the respondent?
The in the court below, I am the respondent. Respondent mother, court below. So this the
Respondent is hereby directed to take all decisions regarding schooling and therapies of the minor child, so and so. Respondent is directed to comply the order dated 21/12/2023. What is this order on 21/12/2023? Passed on IA number 6.
that is for visitation, my lord.
Hmm.
That is for visitation.
To hand over the custody of the minor children, so and
Yes,
so.
we have complied with that order. Now
That's over.
at times the two children, the age of the children is 8 years 6 months as of today and 5 years 20 days. The elder child is a boy child suffering from global development disease. The younger child, the girl child, at times they have not gone to the father. They refuse to go. Now he files an application for contempt. Now the main crux of the matter is that he was enjoying visitation on the 15th day of December 2024. He takes the child. He had visitation from 11 to 2 p.m. At around 10 minutes past 12, apparently the girl child has fallen and hurt herself on her genitals. He has taken the child to a pediatrician and got treatment without informing the mother. Subsequently, when the mother got to know at 2 o'clock when she picked up the child, she's taken the child to a doctor, to a gynecologist. It was the gynecologist from the hospital who has informed Ramurthy Nagar police station. And based on that, she has filed a statement before the police station and a POCSO case was filed. 2 days after that, he files for bail. And after about 3 days, he withdraws his bail application on a guarantee that a B report would be filed. Now, what has happened to the girl child when she has bleeding from her genitals? What has he done? And it's a totally botched up investigation over there. Even during the Mahazar, the accused father is present in the room. Now, what has taken place? We do not know. A B report is filed in that matter. We have brought this matter to the trial court, but since the orders have already been dictated, the orders were passed. Now, in December, 1 minute, my lord.
Have you questioned the B report?
It's coming up this month, my lord. I think on 2026 is coming up. I'm challenging that. I'm challenging the B report. Now, he does not come to pick up the child in December. When there's an order that he enjoys the last week of December, he did not come.
When was the complaint?
Complaint on 15th of December, 2024.
Hmm.
After that, there is an order passed that he enjoys the last week of the year with the children.
he does not come to pick up the children, fearing that the POCSO case is filed on him. But he's got a guarantee from the police that a B report will be filed. He's a US national, not giving a penny for maintenance. He earns in India and sends around 3 lakhs to pay off a mortgage loan in US, but does not take care of the children. Yet he writes emails saying that, how much should I pay? He knows which school the children are studying in. He harasses the school by sending emails over there. He does everything possible to harass the children and the mother. He also files an application for contempt. Now, the main petition is filed under section 26 of the Guardians and Wards Act, which is not maintainable. If you permit me, I'll read out what is 26 of the Guardians and Wards Act, the main petition. Removal of ward from
Cannot be
jurisdiction.
rectified.
Sorry, Miller.
That mistake cannot be rectified.
No, I filed an application.
But already
I filed an application for rejection of
application is filed
petition.
seeking amendment. My application came to be allowed by the Honorable
I filed
Family
an
Court.
application for rejection. He gets enlightened and he files an amendment.
Doesn't matter. Those
Again, he
all,
comes under section 26, 7, 17,
technical
25.
objection shall not
No, the
come in
main,
the way of.
the main prayer is only for visitation and custody of the first child and only visitation of the second child. No love and affection for the girl child. Been separated since she delivered. Now, all of a sudden, love and affection for the girl child. The girl child is going through this. I'm not arguing on the rights of the parties. I'm basically on the welfare of the girl child. Mother does not want to sever the relationship. He has also filed a divorce case. We have come for mediation. We have clearly stated that we are agreeing for a divorce in
When was the
principle.
B report filed?
B report is filed approximately in the month of February, my lord. January or February, I'm not sure on the date.
Till June, mother has kept quiet when there are that kind of serious allegations you're leveling against the father.
I had to get notice in that case, and then there's an adjournment taken over there. So I'm preparing the thing to file this month, this 26th.
What do you say?
My lord, if your lordship can peruse page number 26 and paragraph 33 of the impugned order, paragraph 33, at page number 54, paragraph 33, my lord. May I read? Learned advocate for petitioner has further argued that his minor daughter in her statement has clearly stated that petitioner has not done anything to her. Petitioner has produced copies of first information report and first information statement of said POCSO Act. Respondent has contended that by influencing the police, petitioner got B final report in
Her
the.
statement is recorded by whom?
Please, my lord. She has stated, minor daughter's statement is recorded by the police, my lord. 164 CRPC statement is recorded by the learned magistrate.
Where is that statement? You have a copy of it?
Please, my lord, I have the copy of the statement.
The girl child has given a statement in the hospital. She's a 4.5-year-old girl child at that point of time. Repeatedly for a child to speak up, and children don't speak up in one go. She had to wait till night. Police station, tired. And she's so reluctant after that to speak. 3 times she's subjected to medical examination.
She categorically states that, my lord, father has not done anything to her. While playing in the play area, my lord, she had fell down and she had sustained injury to her private part. Except that she hasn't stated that her father had subjected her to sexual abuse.
The question
that was the
is-
statement of the.
Objections, will see. The respondent.
Lord,
Then counsel appearing to the
My
respondent.
lordship, the
Seeks time to file objections.
2.4, it may be stayed because the amendment of this, he wants to amend the petition.
No,
for the-
that cannot be because I'm convinced with the order, like I can pass an order also now. That the order of the trial court is, it's a legal, a valid one.
But only because of pendency of this petition, my lord, the school is not permitting the father to have interaction in the school. He is not even being permitted to pay the school fees of the children. For that reason, my lord,
Pay, we'll
my
give
lord,
a
I am
direction.
ready to pay, but school authorities are not even permitting me to
Will
enter the
direct-
school.
No, don't, why can't it be paid online?
No, my lord, they are not even given any information to
He
the
can
father.
transfer
my
the
lord.
money
How
to
can
the
I pay, my
mother
lord?
if he has so much
Without
love and
giving any
affection.
information.
Till list this matter tomorrow. By tomorrow, learn counsel for the mother shall give the details of the bank account and the amounts that. need to be
Thursday,
paid.
my lord. Thursday.
Thursday. The amounts need to be paid towards the school fees. Yes.
But on all the occasions, my lord, the father has been saying before the learned family court judge that, my lord, he is ready to pay the school fees and.
Now we'll do and we'll.
Please, my lord.
Other cases
Please,
also.
please.
Yes. Why is it 2:00? Okay. Then partner matters.
Let Writ petition 11619 has become infructuous, my lord. It
We'll
was
decide
only
that.
for summer visitations.
We'll
Under
decide
that
that on Thursday, my lord, anyhow.
Yes,
We'll
anyhow,
decide
that
that
will
on
pass.
Please, please.
Oblige.
No calculation, delete from parter. Does this matter in the usual courts before the court having roster?
Petitioner in two petitions. There were my instructions, my lord, I'm only speaking from instructions. There was an order of 18 September where some non-compliance was happening. Now I'm told compliance has been done. We are willing to proceed with the matter on merits.
What is that?
We are willing to proceed with the matter on merits.
Yes. What is that? Complaints, non-complaints of what?
Disclosure of
We already
assets.
we
Some
already-
passport issue was there which the husband has been reluctant after I have appeared. That has been complied with. Then there was some disclosure of assets in compliance with Rajneesh Neha, though there is no application for maintenance. This is not an issue on maintenance. But my lord had expressed that that should also come on record. That has come on record. Both sides have grouses that I have not disclosed properly, they have not disclosed properly. I am not
So
pressing
what
that for
is
the time
impugned
being.
order? Please come to the impugned order.
But in 1912, the order is at ink page 19.
Yes.
Visitation rights, my lord, the husband has filed for custody and visitation rights, guardianship proceedings. At ink page 26 is the operative portion. Visitation rights had been granted. The father was not.
It's a writ petition of what?
On 1912 and 20817, both are on the same order.
You're on what ground?
Yes, my lord,
2.1?
visitation rights has been granted. To set aside that order, my lord, I filed this writ petition along with, my lord, dismissal of execution petition.
That's the third one.
I filed.
4987, my lord,
No,
what
no.
had happened was.
2.1, 20817.
20817.
There are two writ petitions,
On the same order.
2.1 and 2.2.
20817, my lord, I filed
Same
this.
order,
Then
both.
2.2,
2.2 is, my lord, 4987, WP 4987 of 24. That what had happened was this honorable court, because of the proceedings in 20817, had stayed the proceedings in the family court. But before that, I had already filed an application saying that the mother is not complying with the orders passed by this honorable court for visitation, etc. And I had sought for enforcement. The family court has said that since the Honorable High Court has stayed the proceedings, I am not going to consider the application at all. It could have at
so
best
what is
kept it.
happening with regard to visitation as of now?
Nothing, my lord. At the end of the day, unfortunately to say, things have only deteriorated over a period of time. The mother, it is just the perspective and nothing else. I am not making it confrontational at all. But the mother has taken full advantage of the sympathies expressed by this honorable court and the manner in which this honorable court proceeded in terms of disclosure, etc.
No,
But
that
things-
statement cannot be made for the reason. The petitioner is the
Both are
one who has taken advantage of the sympathies of the court, not the respondent.
Fair. I am not for a moment testing that. I'll take back that statement.
Yes.
Where we stand today is this. Orders of this court have been complied with. Family court's hands are tied because of the orders of this court staying the proceedings there. We are on the issue of visitation, interim order of visitation before this honorable court. I am saying what has been granted by the family court is not sufficient. The mother is saying that what has been granted by the family court is too much. That's all. We are on that issue at all.
Yes, my lord. This honorable High Court, my lord, trial court, my lord, granted visiting rights for 15 days, and for that reason, my lord, this is the case for the year 2021. This is a bona fide. They have to show that, my lord, they have an interest of the welfare of the child.
Where is that IA that is filed for intermaintenance before the
There's
trial
no,
court?
there's no.
I filed a DV Act. Till today, they are avoiding service of the notice and before the trial court. They are not at all taken the.
There you sought for maintenance for yourself.
No, I have not. Only child is concerned, my lord.
Act you sought.
Yes.
What is that case number?
Case number.
Case number I will give.
When is the IA filed by you? IA filed by you?
I have not, maintenance, I have not filed any IA.
Hmm.
I filed an IA for the executing the renewal of a passport.
Not here. I'm asking in the DV court, what is that you sought?
Sought for maintenance for the child and protection order. Because
When was it filed? In which year?
2022.
2022. What had happened to the notices?
That the court, my lord, issued a notice. They awarded service of notice. There is so many times, my lord, that the court is on leave because there was no proceeding officer. Each and every time they are awarding service. They are residing with the same address. The petition.
So if when you're saying that each and every time they are avoiding, what the postal sheriff says?
Postal sheriff, I have to verify, my lord, because they are not taking in last occasion, my lord, it's alternative, hand summons. We have applied for hand summons. It's pending.
Please give this number of criminal miscellaneous.
Please, madam, I will give.
And then what do you say about this visitation?
This
Visitation. Into
visitation. I have contention, my lord. Welfare of the child is important. The welfare of the child and the action taken by the petitioner has to be considered by this. Not it is not some other case like that. He is a heart patient. He has to take care each and every moment. He is also, my lord, ear problem is also there. And each and every time, this Honorable High Court directed the petitioner to cooperate with the medical treatment, but one or the other way he dragged the matter, and finally he lodged a complaint as against the doctors.
It is over.
Now, my lord, is because this intention behind this petitioner, I have to disclose. Kindly see, my lord, you see each and everything, and they filed assets and liability. In that assets and liability, they are transferred the entire house in the name of mother. If it is really has an interest over the child, is the only son, he would have keep that house in his name only, not transferred to the name of the child. Kindly see, my lord, is a transfer of amount, nearly 4 lakh amount to transfer to his mother account, and he has not at all disclosed each. He transferred 60 lakhs to his own account. For what purpose, I don't know. 19 lakhs is a legal fee.
No, why don't you file an application in GNWC itself?
Because of bona fide. No, I'm not.
I'm asking you, why don't you move an application in GNWC itself?
Because so my hurdles is this, my lord. I filed an application for the renewal of passport. He dragged that issue. And he filed one more application, contempt petition, 3 contempt petition he filed. She's working. Each and every time she can't attend the court regularly before the trial court. One or the other, he filed more than 4 cases. That is the reason, my lord, I will look after my child, and I have taken a medical treatment also. And if I filed one more case, on that point of time, my lord, each and every time I have to harass myself. That's the reason, my lord. That's the one reason. That's the one reason. And maintenance is concerned for she's working. That's the reason she can't climb the maintenance.
I said for the child.
Yes,
the domestic violence. Why can't you ask here in GNWC?
Yes,
when he's contesting the matter. Why do you wait for him to come to that the DV court when he's contesting this matter?
Yes, my lord, because
to move an application, I'll ask the court to decide it within 1 month.
Yes, my lord, we are going to
the statement of assets and liabilities that are filed before the it will be transferred to the court below.
Yes,
we'll ask the court to decide it within 1 month.
Yes, my lord.
Yes, then what about the visitation?
Visitation, my lord, is he's don't have any love and affection with the child. I clear, as per the petition, the respondent is clearly established saying that, my lord, only to harass the wife. He's filing one by one application, not at the welfare of the child. And this Honorable High Court, my lord, is directed, and the trial court is also directed. I placed the document. Child is refused to go. I can't force, my lord. Child has to go with the company of the father, because each and every time he is taking photograph to create a document saying that, my lord, say, you have to laugh, you have to eat like this, and he will take photograph and produce before the court. And one incident, he has taken into custody for 10 days. 10 days, my lord, not to take out from the city. Even then, my lord, he taken into various places, but never ever permit him to contact mother. After that, my lord, the child changed his behavior, and he filed a complaint before the police. Police came to the house of the respondent. They threatened. Immediately, she called me as an advocate, my lord. I suggested there is no court order. That's why don't threaten the
Yes.
Child. That is the reason, my lord. Each and every time, his intention is very clear. Not the welfare of the child.
Yes.
It's only to take ego clashes between the wife and child. He is using this weapon. And contempt petition, 3 contempt petition filed by the petitioner.
Yes. Yes.
And kindly see, my lord, in the execution petition, a statement of objection along with the statement of objection, in 20817, I produced the document. When the trial court directed to present before the court the child, but on that day also, my lord, the child refused to go. He is crying, and the medical condition and his mental condition has to be looked into. On that point of time, he forcefully taken into custody over a night. As per the trial court order, my lord,
If the boy is refusing to see the father, what is to be done now?
he has to get the confidence of the. I suggested so many times. He has to take a confidence of the boy.
Oh.
He has to invest his time, and he each and every time.
That's what the court did.
Yes.
That's what the court did. That you
He
have to-
failed because each and every time he want to take a evidence and produce before the court. Even till today, kindly see, my lord, since from birth, he has not given a single NP as a duty.
That is a different aspect. I said that.
Duty of the father.
That we will remind him, and the court will also take care of it. Now, what is to be followed next?
Because
forever,
if
forever you cannot say the child will not see the father. If the child is not interested, there are so many reasons for that. What is to be done for that?
That's my lord. I suggested out of the court. I suggested. I mean, it's a respondent wife suggested you take a confidence of the. I will also be there, with you and take a confidence.
How she wants him to take it forward, that you please tell the court so that the court will understand.
Yes, my lord. On the last occasion, my lord, your lordship is only suggested and taken to Kabban Park and morning till evening. In the morning till evening, he's simply playing. He's simply roaming around. He has not taken into confidence of the child. He has to give something, and he has to give some.
One thing is clear: father needs to have the visitation of the child.
Yes, my lord. I do agree.
According to your client, how she wants it to be.
That's why, my lord, I suggested weekly once is a morning till evening. Weekly once.
What is the order of the court? Let's see.
So order
Ink
page number
page
42.
24 in 1912, ink page 24
Yes.
in
A
1912.
petition is entitled to
That is
interim
where the
custody of
reasons
the
are.
child on any 2 weekends in a month, and preferably during the first Sunday and third Sunday of the month, with prior intimation to the respondent. He shall pick up the child on Friday evening.
So now you are okay if it is made every week.
So morning till evening, because overnight it's
Friday evening, 5 p.m. on Sunday.
Sunday. It's a health of the child has to be considered, and 15 days into 8 days in the during the winter vacation, 15 days in the during summer vacation is also ordered. But that long period, my lord, it's that affect to his.
If it is once in a week, from what time to what time?
So welfare of the child, my lord, has to be. I have to enquire with the respondent, and that too, my lord, he can't force him. He can't force him. He voluntarily has to take a confidence, and he has to take it.
You can take him to a doctor. Take him to.
I also suggested.
Take him to the counselor.
I also suggested that option also, because forceful is concerned, my lord, it will affect its health.
Yes. Yes, Mr. Senior Counsel.
Only two requests. This conversation is perfect. Only two requests. Whatever my lord is considering, one is overnight. Whenever my lord is considering visitation, let there also be overnight instead of only morning to evening.
No, what we do is.
That is one.
We'll modify this order.
No difficulty.
From every week, 10 to 5 on a Saturday or Sunday.
Can it be overnight is the only request that is coming.
For that I'm saying, first 10 to 5, let it go on. In the meantime, no, I have seen the boy. He will not stay with the father without the presence of the mother.
Well,
for that, some arrangement to be made. Let the father, mother, and the child go for the counseling for some period. Then, basing on how the boy is, this request for overnight can be renewed before the trial court.
Just the second request. My lord had said meeting in malls or in Kaban Park, and my learned friend is absolutely right. There's nothing to do with the child. The father is not to be blamed. How long can I walk around in a garden or a park? Let there be home visitation. Even that morning to evening, let it be in my house. Let the child have the environment, a conducive environment or a secure environment.
The problem is that boy at this stage will not come without the mother.
My lord, there has been enough. Again, we are not getting into confrontation. I'm being very careful in my choice of words. But the child can be persuaded. He's a child. There has been some persuasion this way, there can be persuasion
then
that way.
let the persuasion be first and then the overnight custody.
Counseling is what my lord is suggesting.
So first, let this go on every week, and I think then what about the counseling? Then you have to when, where, how.
How do you want to go about it? Are there any institutionalized counselors at the family court? Well, can we keep it tomorrow? We'll just find out on how it can be done. In the meantime, we'll give it a shot and then come back before this honorable court.
And about that IA for interim maintenance?
Look, tomorrow she will not be able to find out. She said a couple of days. Can we keep it on?
One request, my lord.
They can also find out about counselors.
My lord, your lordship directed to bear all the expenses, 50% of the expenses. But till today, even since from 2000.
No, I understood. All
he has
that.
not
given it. That's why I'll pass an order and direct the court to decide your IA to be filed. Filed within 1 month.
Please, man.
Let's just matter on Friday.
Lord, Friday some difficulty. Can it come up on Monday 16th?
Monday.
Monday?
Yes.
16th. Grateful, madam. Great. Lord, basically to inform this honorable court about the arrangement for counseling. That is the purpose.
About counseling?
Yes.
That's the only thing. Yes. And about you, whether it is Saturday or Sunday, that you have to tell.
Yes, I will take a instruction.
Respondent, man. There is no particular the occasion to meet together relating to the discussions as suggested by the honorable court on last occasion. If there are chances to discuss, or if they are willing to discuss, then we are ready to discuss.
No, this is what was on the last occasion suggested, and my
what is the order? View the file.
Well, there are two issues, my lord. One was settlement of the entire case. And the second was, my lord had directed the mother to hand over the child's passport to the father to enable the father to take the child abroad.
This is all done.
Not initially, she said, until the order copy comes, I'll not hand over the passport. The minute the order copy came, we issued a legal notice to her. Then she responds and says the passport is lost.
I'm not aware relating to the
No, you
issue
should
of
be aware
reply. I have not given any reply to the notice.
Mr. Counsel, there is an order by the court. You must have read the order before coming to the court.
Last occasion, my colleague was there.
Might be there, but when you're representing the court, you should know what
But
the order.
only the
I
agreed, my lord. I got the informations relating to the mediation process between us. Except that I am not aware.
You should.
I agree. The court order is there. I should aware.
And it should have been implemented.
I agree. But literally, I am not able to get that particular information and this thing.
So may make one.
Shall we initiate contempt proceedings?
I will check out and I will.
No, shall I initiate contempt proceedings against her for violating the orders of the court, so moto?
That is, my lord, the different issue, but
not a different issue.
If there were holidays and all, and I was not in station. And later on, this one is happened, my lord.
Yes, yes, Mr.
Well,
Angon.
may I make this request, my lord? If the matter could be taken up in chambers tomorrow, we have some more material, my lord. Your lordship may kindly recall on the last occasion in the in chambers hearing. And if she was present today, maybe we could have discussed settlement, because my client has been requesting her to give a proposal for settlement. There has been nothing coming forth from her side. Lord. We are ready to
That
Then we will look
there
at
must be the
look at the
reciprocal.
impugned order and pass orders. Where is the impugned order?
So the impugned order is only with regard to visitation, my lord.
Please come to that. Now, you want a chance or you want me to pass orders on the merits of
No,
it?
my lord. There is a let them give the opportunities, both parties relating to
It
the.
is you, your client, who said that she will come up with a proposal, not from that state side.
Even I thought they are informing us
It's not about you
that
thinking,
there
Mr.
will be the
Counsel.
communication gap might be, and give me the
Let's
week
matter
time.
on Monday, by the time, if the instruction, if no, if by the time, but within 2 days from now on, from today, the respondent shall come up with a proposal. And if the proposal works out, it's fine, or else the court will pass orders on the merits of it on Monday. Yes. Oh, 2 o'clock. It's only one.